Tonight, former Supreme Court Judge Justice Atuguba takes on Supreme Court for acting unconstitutionally and in bad faith on a host of cases, including the controversial Gyakye Quayson case.
The Gyakye Quayson's decision by the Supreme Court is, with all due respect, scandalous, in that the court, in the teeth of the settled maxim, res judicata et non quaeta movere, re-adjudicated the same matter that has been adjudicated upon by the High Court on the merits.
We'll also hear his verdict on the Dome-level case in which CDD had tried to get his removal reversed after he was forced to proceed on leave. And Top Story is always brought to you by Vodafone. Well, today we've been hearing from former Supreme Court Judge Justice Atuguba, who has been taking on the Supreme Court for acting unconstitutionally and in bad faith in a host of cases, including the controversial Gyakye Quayson case. We'll bring you his views on that pretty shortly. But he also talked extensively about the removal of the former Auditor General Daniel Dome-level, and in that case, as you may recall, after he was asked to proceed on a long leave, the CDD had gone to court to challenge that. Well, the court failed to hear the matter on time, and today the former Supreme Court judge himself has been assessing that. He believes the conduct of the Supreme Court in that matter was unconstitutional.
This trend has continued in very recent times. Thus, in Ghana Center for Democratic Development and 8 others versus Attorney General, as Gyakye JSC delivering the judgment of the Supreme Court stated, judgment was delivered in this case on the 21st May 2023, long after Mr. Dome-level had been pushed out of office. Coincidentally, it was on the same day that the Supreme Court also delivered judgment in the case of Professor Gyakye Quayson, a northern background, okay, and 7 others, and the Attorney General. In this case, the plaintiffs challenged the constitutionality of the Imposition of Restrictions Act 2020 Act 1012, which was enacted in consequence of the deadly coronavirus COVID-19 pandemic. Thank God that is passed. But the developed countries are saying a more serious one will come. They are not God anyway. It can unhappily be said that the Supreme Court acted unconstitutionally and in bad faith when it inordinately delayed in adjudicating the National Media Commission and Attorney General. As on that panel, as I said, but don't blame me, that I was not in charge of listing. When it was listed 3 years later, we promptly, it was in November, we decided it within a month or so. Still, the blame comes from the judiciary, as well as the Dome-level and COVID-19 cases for short. This is because, okay, let me explain this better. I'm saying that it can be said that the Supreme Court sometimes has acted unconstitutionally and in bad faith. And I'm referring to National Media Commission and Attorney General, as well as the Dome-level and COVID-19 cases. I've told you about the national media. The case of Dome-level, I've told you, judgment came long after the man had left. And the COVID-19, those impositions have had their thorough effect. The COVID-19 itself has passed. Now judgment has come saying that they were unconstitutional. This is because it is the constitutional duty of the Supreme Court to enforce the Constitution forthwith when it is breached. That is the mandatory duty under Article 2(1) of the Constitution. Those days, our judges could speak. Unquote. In the National Media Commission, Domelevo and COVID-19 cases, the Supreme Court failed to suppress the mischiefs of the infringements of the Constitution for an inordinate period of time. Of course, as I said earlier, the delay can come from the panel or is listing for hearing. And we all know who can direct listing of cases in the Supreme Court.
Also on the Gyakye Quayson case, he also declared that the Supreme Court's decision on that particular case was scandalous.
The Gyakye Quayson's decision by the Supreme Court is, with all due respect, scandalous, in that the court, in the teeth of the settled maxim, res judicata et non quieter movere, re-adjudicated the same matter that has been adjudicated upon by the High Court on the merits. Never seen this type of thing in any judicial system. If the certificate of renunciation is so mandatory and conclusive, why was it not conclusive in its effect to qualify Gyakye Quayson when he received it dated 26 November 2020, whereas the parliamentary election was held on 7 December 2020?
And it has been listening to former Supreme Court judge who has been speaking today at a public lecture detailing his thoughts on the judiciary, on the subject of democracy and the judiciary's contribution to maintaining one. I want to bring in on the subject you just had there on the Gyakye Quayson matter, but also on the dome-level issues that he's raised, his accusation that the Supreme Court sometimes acts unconstitutionally and in bad faith. Joining me right now is the Director of Legal, Frank Davis, who of course is on the New Patriotic Party's committee, Constitutional Legal Committee, joins us on the telephone line now. We'll be joined also by Abraham Amaliba, who is the Director of Legal for the New Patriotic Party. Mr. Davis, thanks for your time here on Top Story.
Thank you, Evans, and good evening to your cherished listeners and viewers. But let me correct you. You always do the Evans, and I correct you. You continue doing it. I'm not the Director of Legal Affairs of the NPP. That portfolio is held by Guy Nwakun. I am the Chairman of the Constitutional and Legal Committee of the NPP. So get my designation right, please.
Davis, thanks.
Amaliba has long ceased to be the Director of Legal Services of the NDC. It is now a digital macro.
And I know
Amaliba is in charge of conflict
and I know both of you have this very interesting relationship. Thank you very much, Davis. Yes. Your reaction to what you just heard there from the former Supreme Court judge, especially on specifically to the Gyakye Quayson matter.
With great and enormous respect, I said with great and enormous respect for Justice William Atuguba, great eminent jurist of our time, that on this score alone, I think he has misjudged, misconstrued, and his interpretation of what happened in the education case is skewed. I am with great respect. He is falling into the same piece of misunderstanding that most people are falling into, and it's quite unfortunate. I have such great respect for Atuguba, but it's quite unfortunate that sometimes our retired justices try to wait and get involved in these matters. But let me say it for the often time that when we sued out the election petition in the High Court, it was for interpretation of Article 94(2)(a) of the 1992 Constitution, not interpretation per se. but that we were saying that by the strict dictates of Article 94(2)(a) of the Constitution, Gyakye Quayson was not eligible to hold himself out for election, when at the time of the close of nomination, he had not renounced his Canadian citizenship. Okay? The case revolved on Article 94(2)(a). We went for enforcement of that article. Now, the judge, in delivering his judgment, relied on a similar provision under Article 94(1)(a), which revolved the issue in the famous Assin Rawlings case in the Supreme Court. But Assin Rawlings was on 94(1)(a) as opposed to 94(2)(a) in the Gyakye Quayson case. So you realize that when the appeal was lodged in the Court of Appeal, when Atuguba took over, and the appeal was lodged in the Court of Appeal, one of the strengths of that appeal was that the judge had embarked on a journey of interpretation of the Constitution, 94(2)(a). Okay, and that when it comes to a strict interpretation of articles in the Constitution, only the Supreme Court which has that power. All right. In the end, he also said that 94(1)(a), even though akin to 94(2)(a), there has not been any definitive pronouncement by the Supreme Court on Article 94(2)(a). For that matter, the Court of Appeal should hold its hands and the matter be referred to the Supreme Court for interpretation. Seized with that, we decided, as lawyers for the plaintiff, that let's settle this matter once and for all. So we also invoked the original jurisdiction of the Supreme Court for an interpretation of Article 94(2)(a). The case in the Supreme Court was not about determining the merits of any case in the High Court. That is why I disagree with Atuguba. If he had taken pains to read what we filed in the Supreme Court, I don't think he will make this pronouncement. The case in the Supreme Court revolved on the interpretation of Article 94(2)(a), which had not received any authoritative pronouncement from the Supreme Court. The another case was on Article 94(1)(a). So the Supreme Court did just that. So this issue of res judicata does not apply. Res judicata does not apply because it was not on the strength of 94(1)(a). It was 94(2)(a). So the Supreme Court had every power to cause an interpretation. And that's exactly what they did.
Stay with me. Abraham Maliba is with me. Abraham, is that your understanding of what happened in the Supreme Court too?
I disagree, but I think he's corrected my position now. I'm director for conflict resolution. Nothing could be further from the truth. And I think that the learned jurist did justice to those issues that we raised, particularly the Gyakye Quayson case. The matter that went to the Cape Coast High Court was about Article 94(2)(a). I agree with him. At that court, I, then lawyer for...
Hello, Abraham. I may have just lost him there on the line. Abraham Maliba? Okay. Do you have Frank Davis on? Oh, unfortunately, I lost both the gentlemen. Hello, Abraham?
Hello,
I lost you. Yes, briefly. You're back now. Yes, you're making your point, Abraham.
So I was saying that Article 94(2)(a) was actually what they sent to court. And at that point, I raised the issue before the High Court that this borders on constitutional interpretation, so it should be referred to the Supreme Court. He, speaking to you now, said there was no need for interpretation. So the judge determined the matter at the High Court. And we also how the judge determined the matter. Justice Atuguba is saying that once the matter was determined at the High Court, the Supreme Court shouldn't have entertained the same Article 94(2) that was sent to the High Court. And that is where Justice Atuguba is right by saying that the matter was res judicata because it was already determined. Now, In this same matter, Article 94(2)(a), after we raised the issue at the High Court and it was shot down that it should be sent to the Supreme Court for interpretation, at the Court of Appeal, we still raised the issue that this is a matter that should be sent to the Supreme Court for interpretation. It was shot down. We went to the Supreme Court itself. The Supreme Court shut us down. So we were shocked and surprised that the plaintiffs, led by Frank Davis, will now file a fresh writ calling for an interpretation of the same matters he had opposed from the High Court through to the Court of Appeal and even at the same Supreme Court. Indeed, you remember there was a certain 3-2 decision in which 2 justices said that, yes, there was a matter for interpretation, but we lost by 3-2. After that, he then went to the Supreme Court and filed a writ for interpretation. Now, you can evoke the jurisdiction of the Supreme Court for interpretation by filing a writ as they did, or by referral as we were doing long ago from the High Court. So Justice Atuguba is right by saying that the matter was already determined, and so the Supreme Court couldn't have, as it were, determined the matter again.
But the specifics of what Frank Davis says is it borders on what the Supreme Court was interpreting. It was a constitutional provision.
Say it again.
I mean, there's a constitutional provision that needed to be interpreted, and the Supreme Court's jurisdiction is very clear.
But was it not the same interpretation we're calling for? Aren't you following what I'm saying? There was this same interpretation issue that I raised, followed by Justin Kwabra, followed by Tachikata. We raised this. Now, when the matter was before the Supreme Court per his writ, we filed a motion saying that the Supreme Court has no jurisdiction to hear a High Court, a parliamentary petition. What they told us was that they were not going to determine that, and that they will address it in their final ruling. As we speak, that has not been addressed in the final ruling. So we are not saying that the Supreme Court has no jurisdiction to interpret the Constitution. What we are saying is that this matter was already determined, and if the Supreme Court was just doing an interpretation, then it didn't need to go into determining the matter. It would just interpret and refer the matter to the appropriate court to deal with the matter.
I mean, Frank, considering that this is coming from Justice Atuguba, and considering his analysis of the matter, he is very, very clear that what the Supreme Court did, that the Apex Court had then now was actually trying to say that it had a concurrent jurisdiction of a parliamentary election petition with the High Court, which was alien, he says, to the 1992 Constitution.
Evans, with great respect to you too, with very great respect to you too, you are a seasoned journalist, but you are not a trained lawyer. So don't stray too much into what Atuguba said, because you wouldn't understand what he said. With great respect to you.
Well, except that I'm just quoting what he said.
Let me correct what, please, Evans. These are legal matters.
Yeah, but it's a question I'm asking. I mean, based on what he has said.
With his reasoning, but don't say his analysis shows that the Supreme Court did otherwise.
No, but his point is simple, that they, according to him, this is a High Court. There's a priest of the High Court when we are dealing with the parliamentary procedure, and that the Supreme Court swayed into that area. We
did not go to the Supreme Court to determine a parliamentary election petition. The legion of cases that Mr. Tachikata raised, respected lawyer, the legion of cases that he raised, if Atuguba would take pains to read those cases again, he will see the stark difference between what we took to the Supreme Court and what they were canvassing. Most often than not, when these things happen, let us all read what the judges said in their judgment. We went to the Supreme Court for only one matter, and it's a true and proper interpretation of Article 94(2)(a), and that when does it kick in? When a person is supposed to be eligible for parliamentary elections at the close of nominations. The Supreme Court did not go into any other matter. And I'm saying, I was not the judge in the High Court. I take a matter to court, a judgment is delivered, you appealed. Now the judge referred and took comfort in Article 94(1)(a). And his reasoning was that the language in Article 94(1)(a) is the same as in 94(2)(a), which is the case anyway. 94(1)(a) and 94(2)(a) bear the same language. And that was what was determined in the Zanoto 94(1)(a). Now, what Amaliba, Justin Pavra, and later on Leonard Senior Kachikata did was that they were saying that because Article 94(2)(a) had not received any authoritative pronouncement from the Supreme Court, and that it was Article 94(1)(a) that had received interpretation, the judge, the High Court judge, had constituted himself into a Supreme Court and determined the provisions of the Constitution or the articles in the Constitution. That was one of their main plans of appeal in the Court of Appeal. The reason why the Court of Appeal did not make a referral to the Supreme Court was for basically different issues. Atuguba should read the rulings of the Court of Appeal in those matters. He wasn't coming to court, he should read. Now, when Tachikata brought the matter to the Supreme Court, the decision was 3-2. Okay, now we said as plaintiffs, in order to put this matter to rest, why don't we then invoke the original decision of the Supreme Court to properly interpret 94(2)(a), which is exactly what we did. What did the Supreme Court do wrong? What did the Supreme Court do wrong by interpreting 94(2)(a), which has not received any pronouncement from the Supreme Court?
Well,
I think we should rather be praised and we should be commended for calling for that interpretation. So far as I'm concerned, that is the only true pronouncement that has been made. No other court has come with any other decision. So let us wait. Maybe subsequently something else may arise. But that is what the court has interpreted in 94(2)(a). So I don't see how it could be scandalous. I don't see how that be praised. I don't see the basis for res judicata. It's got nothing to do with res judicata. Nothing.
Abraham, part of this case is criminal. And what's the update on that?
Well, before I get to that, if the Supreme Court is interpreting a parliamentary provision such as this, a matter which has to do with parliamentary petition, then the Supreme Court shouldn't have gone ahead and declare that Gyakye Quayson is not eligible to contest the elections at the time he did. The Supreme Court should have just simply interpreted the Constitution. But when the Supreme Court goes on to say that the MP or Gyakye Quayson is not eligible at the time, then it means that the Supreme Court is engaged in determining a parliamentary petition, which is left to the High Court.
Abraham is wrong.
Now, the criminal aspect is ongoing. Because we went on vacation, the hearings were not ongoing, but we've resumed and we are back in court this October. There will be a last opportunity for the lawyers for the accused person to cross-examine their first witness, and that is what will happen at the next trial.
Abraham Amaliba, thank you very much. Frank Davis also. What's your view on this matter? Both matters, really. And because of time, we didn't quite explore the first issue that Mr. Atuguba had raised, a former justice on the Supreme Court who had tonight raised serious questions about the James Gyakye Quayson's case, but also the Daniel Domelevo case, a former Auditor General. I want to hear from you, 055-11-11997.